Check, 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 check. ಗೊತ್ತಾಯ್ತು audio. ಓಕೆನಾ ಕೇಬಲ್ ತಗೊಂಡ್ಬಿಟ್ಟು ಹೆಂಗಿರೋದು ಹೇಳಿ ಕನ್ನಡ ಅದು ಕೊಡ್ತೀನಿ ಚೆಕ್ ಚೆಕ್ ಆಡಿಯೋ ಗೊತ್ತಾಯ್ತಾ
Hello. Hello. Students, please be seated. Yes.
ಅವ್ರು ಕೆಳಗಡೆ ಹೋಗ್ತೀರಾ
A very good morning to one and all present here. It is my privilege and honor to extend a warm welcome to everyone gathered here for the session titled Constitutional Governance, Tax Administration and Judicial Review. I take immense pleasure in welcoming our esteemed dignitaries to this session. I extend a warm and respectful welcome to our chair and speaker for the session, Dr. Tarkesh Molia. Dr. Tarkesh Molia is a seasoned legal academic with over 2 decades of experience in legal education, research, and administration. He holds a bachelor's from Gujarat University, an LLM, and a PhD in law from Saurashtra University. Dr. Molia has an impressive research record, having led and co-investigated 6 sponsored research projects for prominent bodies, including the National Human Rights Commission, the Ministry of Law and Justice, and the Government of Gujarat. Notable among these are a project on jail reforms in Gujarat, a study on the efficacy of Lok Adalats, Nari Adalats, and fast track courts. He has 15 publications in reputed journals indexed in Scopus and Web of Science, covering themes such as federalism, disaster management, freedom of religion, environment compliance, and constitutional law. Dr. Molia has guided numerous postgraduate dissertations and has served as a PhD external examiner and visiting professor at several institutions. He is an active member of prestigious legal and public administration associations and has been recognized with Best Paper Awards, including at various national conferences. His expertise in constitutional governance, administrative law, and human rights makes him a valuable contributor to discussions on tax administration and judicial review. We welcome you today, sir. And I kindly request Dr. Suvarna Raj ma'am to present a sapling for as a token of our gratitude and appreciation. I now have the honor of introducing our speaker for the session, Dr. Sunil, Assistant Professor of Law at KSLU's Law School, Hubli, and currently serves as Assistant Registrar at the Karnataka State Law University. Dr. Bagade has been serving at KSLU since July 20. IPR and child rights. His specialization in business and trade laws, combined with his research on federalism and judicial approaches to governance, makes him a valuable contributor to discussions on constitutional tax administration. We welcome you today, sir. I now
Yeah, no, more better. Yeah. Okay. Good morning, friend. Am I audible? So, today's theme is constitutional governance, administration of tax, and judicial review. So, this is the theme of the conference. Now, when we look at all these three components, the constitutional governance, administration of tax, and judicial review constitute an interlocking triad that defines the quality of democratic statehood in the modern world. So now coming to so we'll understand this component because I'm just introducing the theme. I will be talking on the subject later on. So that we are all on the same page to understand that and what can be the outcome of this session. And that is very essential when any session is conducted, we need to take home something from as a learning. So the constitutional governance refers to idea that all the organs of the government, whether it is a legislative, executive, or judiciary, derives the power from the constitutional framework. All these organs derives the power from the constitutional framework, which are based on certain doctrines and principles like separation of power, rule of law, limited government, federalisms, and so this framework sets the outer limits. So this framework sets the outer limit within which the executive as well as legislative are supposed to operate or function, thereby preventing arbitrary concentration of power and ensuring accountability of governance in the country. So that is what the constitutional governance means, that all the organs operate within the outer limit provided by the constitutional framework and thereby preventing the arbitrary power by this authority. Now, within this structure, tax administration occupies a central place, as a taxation is not merely a fiscal tool, but also key instrument of public policy and economic redistribution, because that is the object of the tax. It is not only fiscal tools, it is a greater object in the constitutional parlance that it is meant for economic reforms and redistribution of the resources, because one of the object in the preamble is justice, social, economical, and political. So from where do you derive the economical justice? It is this particular administration which caters to this particular aspect. The tax laws and their enforcement must therefore operate within the clearly defined constitutional boundaries, invalidating any levy that is ultra-virus the Constitution, discriminatory, or violative of fundamental rights. At the same time, efficient, transparent, and fair tax administration is essential for revenue mobilization, public trust, and overall legitimacy of the fiscal democratic compact between the state and the citizen. So this is the basically the object of tax administration. It has to be transparent and there has to be an accountability. So now these two organs. So one is, when I say the tax, the governance, it is mostly by the legislature who is empowered to tax, and the executive who collect the tax, they execute the things. Now, to ensure both these things, you need an arbitrator or a referee to adjudicate that all the things are operated as per the constitutional framework. And there comes the role of judiciary to achieve this object between the collector and taxpayers. So now the judicial enters as a constitutional safety valve. Judicial review empowers court to scrutinize both primary legislation and administrative action, both as I stated. By dealing ultra-virus, unconstitutional tax laws, void, striking down arbitrary assessments, and ensuring adherence to the principle of natural justice. Effective judicial review mechanism in a tax matter can reduce evasion, enhance compliance, and reinforce the credibility of the tax system. So these are the basic objective for which all these three exist. And if we see in this particular theme, what we are going to see is that, and we are going to examine the doctrinal development which has taken place in the constitutional governance, case law trends because it deals with the judicial review, and comparative models. And also how robust constitutional governance, discipline, tax administration, and an independent judiciary together contribute to fair, efficient, and accountable tax regime in democratic polity. So this is the introduction of the theme. And now I think Mohan Paris has joined. Okay, so meanwhile, we can start with sir. So I invite Sunil and Bagade sir to start with this presentation, and we have one another speaker who is Justice Mohan Paris, who is a former judge of the Supreme Court of Sri Lanka. He had also been the Attorney General of Sri Lanka. So he will be joining very soon online. Meanwhile, I will request Bagade sir to proceed with his lecture or a discussion on the present topic. I welcome you, sir, please. Yes.
Respected chairperson of this technical session and Honorable Justice Mohan Paris, who will be joining, or I believe that he might have joined online, and the principal and the teaching and non-teaching staff of this particular college, as well as the students who are attending this particular workshop or this particular conference. So good morning to all. The point which we are supposed to look into at this particular juncture, after having attained independence in the year 1947, after adopting the constitution in the year 1950, where we stand in the federal system of governance. What exactly the federal system of the governance? The developments which are taking place in the present day order, especially in the field of taxation, are really in tune with the basic aspects of the federalism, are the things to be inquired into, to be looked into. When we speak in terms of the judicial review, I strongly believe that there should not be a scope of judicial intervention in when it comes to the aspect of federalism, because federalism essentially means coexistence, not competitive existence. Okay, when state starts competing with the union or union starts competing with the state, the federalism collapses. So to have a federal structure united, the purpose with which the constitution was adopted, the purpose with which the federal structure was contemplated initially, okay, there should be a limited scope for the judicial intervention, and that's how the GST should have been thought of, and that's how the GST should have been incorporated, provided for. Please see, when we speak in terms of the federalism, quite an interesting aspect of the Indian federalism and uniqueness of Indian federalism is that we call our federalism as a quasi-federal structure, wherein we have systems, unitary form of governance we have adopted. At the same time, federal structure requirements have also been a part of the Indian federal structure. So we are flexible. At the same time, we are rigid in a given point of time. So such is the Indian constitutional framework, governance, which we have adopted. So basically, when we contemplate federal structure, remember, federalism is not a system wherein central controls whole and soul. Okay, we have seen a COVID situation wherein top-down system was adopted. From the central government, there used to be a guidelines and the state was supposed to follow that particular guideline. That's a unitary kind of structure. That's a unitary kind of working. Okay. But in federal structure, no such system is contemplated. Both have an equal responsibility. The state as well as the union government have an equal responsibility of ensuring the governance in accordance with the constitution. So at their sphere, they are autonomous. Okay. No doubt, central government in Indian constitution has a superior power. Extremely sorry. That's how unitary features can also be found in the Indian constitution. Okay, by way of residual power being conferred to the state or to the central government, and the central government exercises a power of a superior nature. But to a larger extent or to some extent, states are also have that autonomy to decide what is best suited for that particular state. Remember, one important aspect which we need to explore upon is what kind of federal, especially speaking from the financial aspect, economic aspect, what kind of federal structure we have. We have asymmetric federal structure. Asymmetric federal structure in the sense that all states are not equally placed when it comes to the economic development. States are not equally equipped when it comes to the economic development. States are not on the same line of development, same platform of development. There are inequalities. Some states are better performing, some states are generating revenue better than other states, some states are really industrialized states, some states are essentially dependent upon the agriculture, some states like Goa, they depend upon the tourism most. So in that way, we have different set of states wherein their development is at different stages. Okay. So the requirement of the state is better defined by that particular state. So in the earlier tax system, if we can try to understand, there was bit of a autonomy, taxation autonomy, which the states enjoyed. States could define their taxes. Especially, see, remember, we have two types of taxes. One is direct tax and another one is indirect tax, right? So in case of direct taxes, generally the central government had the maximum claim and it used to collect the maximum share. Whereas in case of indirect taxes, state had the power to define the tax, sales tax. Okay, the state had that power. But after coming into existence of the GST, the system underwent change. Whole system underwent change. That we need to analyze and understand what implication GST had on the federal system of functioning of the state. So as I told you, tax autonomy to some extent the state had. That's why if you see the 7th schedule of the Constitution, okay, 7th schedule of the Constitution provide many lists? 3 lists. Very good. Okay, list 1 is referred to as union list. List 2 is referred to as state list. List 3 is referred to as concurrent list. Okay, very good. So with respect to the subjects which have been enlisted in list 1, central government, union government has an exclusive power to pass administrative orders, legislative measures, at the same time impose tax. So there is no intervention of the state. Similarly, in matters relating to the items which have been enlisted in second list, state had an exclusive to impose tax. So such was the kind of the distribution of the power contemplated under the Constitution of India. So that's how the federal system was functioning prior to the introduction of GST. Subsequent to the introduction of GST, what happened? One size fits to all kind of notion came into existence. One nation, the basic theory was one nation, one market, and one regime of tax. So that was the basic notion with which GST was introduced. No doubt, GST speaks of the transparency. GST speaks of the accountability. GST speaks of a proper revenue collection. And also it aims at reducing the efforts in the matter of revenue collection. So all those are the positive aspects of the GST. And more importantly, please see, another important feature of Indian federalism is we are cooperative federalism. We have adopted a system of cooperative federalism. We have intergovernmental organizations, we have planning commission. Okay, there are different bodies which cooperate with the state, which acts as a conduit, which acts as a liaising departments between the state and the center, and accordingly, there gets established a cordial relationship between state and the center. That's how the Indian federal structure functions. Okay, that's an essential aspect. That's how the coexistence is ensured between the state and the center. Conflict is reduced between the state and the center. GST is also functioning on that same premises. If you see the GST, okay, under GST, there is a separate council called GST Council, Goods and Services Tax Council. if you see the composition of the GST Council, we have Union Finance Minister as the head, okay, Union Minister for the state as the member, and then the finance ministers or revenue ministers of the different states as the members. So there is a participation of each state in the decision making process. So no state is left. No state is left. So every state's interest is being addressed because representation is ensured. So participation is ensured. So that's an essential feature. So that is also an essential aspect with respect to cooperative federalism. But the point is, please note, in case of asymmetric federal structure, wherein each, say, Article 371 of the Constitution of India, if you can recollect, that forms a special provision of the Constitution of India. Okay, whatever the states, whatever the areas which are backward, which have been considered as backward, special package can be given under Article 371 of the Constitution of India. That is an exception. That's a measure which is brought into existence to address the inequalities prevailing in economic circumstances, economic aspects. But in case of GST, that particular factor was not considered. That particular factor was missing. Why I am telling you is, see, GST Council decides that particular product should have 18% of tax. Right? So once that particular 18% of tax is determined, it is applicable to India, irrespective of the requirement of the state. A particular state may need 19% of the tax because its revenue is less. Or particular state may require less than 18% because it might be having a high income. So there is a variation in matters of revenue generation. Remember, essential source for any country or any state is revenue. Through revenue, it earns the income, and that income is going to be spent for the purpose of the various developmental projects. Okay, so if the power fixing the tax is taken away and given to a council which acts on the principle of majority decision, under that circumstances, there is always a possibility that the state which doesn't have an adequate representation, which has less revenue generation, may lose the battle, may not be in a position to raise its voice and stand for the revenue what it entitled to. There is another principle based upon which GST was built upon. That is revenue neutrality. So, what is that revenue neutrality? Whatever the tax which the state collects in the new regime should be equal to the tax which it was collecting in the old regime. Okay, that was the basic principle based upon which the GST was contemplated. But in the new regime, what is happening is, whatever the tax rates which the state or which the GST Council determines, sometimes it may result in loss to the state. States are suffering the loss because earlier they might be collecting 19% of the tax. Now I have reduced it to 18%. So 1% of the loss the state is incurring. Sir has done. Okay. Another 5 minutes?
Yes.
Will that be fine?
Yeah.
Okay. Okay, so the states are undergoing loss because that particular factor, that earlier how much it was getting the revenue, and presently how much revenue, tax has to be imposed so as to meet that particular neutrality principle, that is also not taken into account. Third important aspect is there is a provision for distribution of the revenue, whatever the state collects. Whatever the union collects. There is again a provision for the payment of the compensation. GST compensation. Whenever the state suffers loss, that loss is made good by the union government. How far union government is fulfilling its obligations, how far it is in a position to pay the compensation, how far it is in a position to make good the loss which the states are suffering, that has also become a biggest question. recently Karnataka government had filed a petition before Supreme Court of India requesting the Supreme Court to direct union government to pay whatever the dues which are withheld by the central government. So that is changing the very notion of the very notion of cooperative federalism, a competitive federalism, wherein we are trying to take the help of the judicial system to resolve our demands under the GST and get our dues being cleared. So that's how, in case of GST, which contemplates one situation fitting to all, one system fitting to all, is trying to miss the basic aspect of the Indian federalism, that is asymmetric nature. If that is not taken into account, then there cannot be an equal growth. Please look into Article 14 of the Constitution of India. What Article 14 says? Equality between equals. Okay, there should be equality between equals, not among unequals. Okay, when there are unequals standing on a different platform, the Constitution contemplates affirmative action. It provides for a differential treatment. Okay, constitutionally guaranteed differential treatment. Whereas in case of GST, we did not contemplate that basic principle, which was part of the Indian Constitution. When states are at the different stage of development, states are generating revenues at a different level, states' demands are different in terms of economic development, accordingly, the law should be to meet the requirements. That is not being contemplated under GST, because of which GST, strictly speaking, doesn't fit into the system of federal governance. And remember, more importantly, in case of federalism, what is being essentially contemplated is distribution of powers at different level of governance. But in case of GST, there is a centralized tendency. Every matter, every matter gets decided at the GST Council, but not at the state level. But not at the state level. Okay. So these are the few of the observations with respect to GST, how federal structure exists, and how GST is not so much better suited within this particular framework of tax neutrality, tax autonomy, as well as the payment of compensation, as well as giving what is due to the states by the union. If that is not ensured, state will suffer. If state suffers, the development suffers. Okay, so the very purpose of revenue collection will not be fulfilled if these factors are not adequately addressed, and really the democratic principles are being incorporated into the functioning of the GST. More importantly, the federal system. Okay, the autonomy to a certain extent has to be given. It's not that complete autonomy of the state is taken away. In matters relating to excise duties, in matters relating to petrol, diesel, etc., states have autonomy to some extent, but in rest all matters, the autonomy is taken away. Okay, the council exercises that particular power. Council decides the rate which is applicable uniformly. Uniformity is good in matters of trade and economy, but whether it fulfills the developmental need of the state, that is also to be looked into. It's not that all the states are on equal platform. It's not that all the states possess that industrial capacity, progress by themselves. Okay, if that is not the situation, then we need to look into the requirements of the each state, and accordingly we need to try to provide for the development in such a way that they should have an autonomy and there should be more cooperative structure than a competitive or one-sided decision being imposed on the state, or central decisions being imposed on the state. Okay, with this, I conclude my presentation. I thank the organizers for giving me the opportunity. Thank you. Thank you. Thank you. Thank you. I'm sorry.